Hi, good morning, everyone, and thank you for attending today. I'm Kathy Halliday, and I'm a partner in the employment team at VWV, based in the Birmingham office. And I'm joined today by my colleagues, Joe Oliver, who's also a partner in the employment team, who's based in our Bristol office. And we both work with the firm's third sector clients to a considerable degree. And we also have with us Jessica Scott Dyer, our professional support lawyer, who's going to help answer your questions either online in the Q&A box at the bottom of the screen, or if we have time at the end, as Tamar said. So in today's session, we're going to look at the decision in the Harbour Trust against Brazel case and talk you through some of the issues that it raises for employers. So I'm going to start by setting the scene and talking about the judgment. And Joe's then going to look at holiday pay calculations and the impact of the judgment. And then I'm going to finish by looking at a few strategic considerations. So the starting point is to consider what are our UK holiday entitlements and rights to holiday pay. So essentially the working time regulations, which came in 1998, introduced initially 4 weeks leave, which was the 4 weeks minimum requirement that came from the Working Time Directive from EU law. And then subsequently, under Regulation 13A of the Working Time Regulations, an additional 1.6 weeks leave, domestic leave, so that's just for the UK, was introduced. So that totals the 5.6 weeks leave that we're talking about today. And then in terms of pay, the provisions are also set out in the Working Time Regulations, and Regulation 16 provides that holiday is to be paid at the rate of a week's pay for a week's leave, which sounds logical, and that a week's pay should be calculated under section 221 to 224 of the Employment Rights Act 1996. So, you know, in outline, it's relatively straightforward. If you're a full-time or part-time worker working 52 weeks a year, when you take your leave, you get a week's pay. So if you're full-time and you earn £200 a week, you'll get paid £200 a week if you're on a week's holiday. And if you work 50% contract, 52 weeks a year, so you work half a week in terms of hours, you earn £100 a week, whether you're working or you're on holiday. So that seems sensible, it's straightforward, and that hasn't changed. The issue came primarily really because of the drafting of the Working Time Regulations, which allows you to prorate holiday pay calculations if you're working reduced hours in a working week, but doesn't expressly provide for prorating for part-year working. So if we break this down a bit, if you are a full-time worker and you are working you have 5.6 weeks holiday entitlement, you essentially work for 46.4 weeks. And if you do that as a percentage, your holiday as a percentage of the weeks you work, you come to the figure of 12.07%. And both ACAS guidance and the government guidance recommended that you use this equivalent percentage of 12.07% as a method of calculating holiday entitlement and holiday pay for atypical part-year and hourly paid staff. So this covers term time only, casual workers, or indeed anyone who works less than 52 weeks a year. So Mrs. Brazel, you might be aware she was a music teacher in a school, and she worked term time only. And what she said was, well, if you look at the working time regs, it doesn't say my holiday pay should be prorated by using a 12.07% calculation. What it says is that I'm entitled to 5.6 weeks holiday pay. So if we take the calculation, say she was working 32 weeks a year, and she's saying she wished to be paid for 5.6 weeks holiday pay, and you do the same calculation, this gives a calculation rate of 17.5% for entitlement to holiday and holiday pay. So essentially this case means, would mean that employees who work part-time by working fewer weeks in a year receive a higher percentage rate for holiday pay. So if you take an extreme example, if you only work 12 weeks a year, but you were on a permanent contract and you still were entitled to 5.6 weeks holiday pay, that gives you a 47% real rate of holiday pay. So this might seem inequitable, indeed, but using a percentage for calculating holiday and holiday pay going forward is not acceptable, because what this case says essentially is that people are entitled to 5.6 weeks holiday. Next slide, please. So what is the impact of the judgment? So I think we've got a poll now. In the judgment, Supreme Court described the result as a slight favouring of workers with a highly atypical working pattern. And the question is, do you agree? Yes or no? You can vote now. So actually that's quite interesting, quite a large proportion, about 50-50, just under 50, 47%, 53%. Well, I think it probably depends what sort of organisation you work on. So for organisations where you perhaps have fewer casual workers or workers who work part-time, which I think is what the Supreme Court were thinking about, that might well be the case. But for organisations where there's a high number of casual workers or part-year workers, term time only working, for example, then clearly the impact is more significant. So the judgment, what was the Supreme Court decision? So what the Supreme Court decided was that permanent, part-year and irregular hours workers are entitled, however many weeks they work in a year, to 5.6 weeks statutory holiday. They repeated that holiday pay is to be calculated in line with the working time regulations and the weeks pay provisions of the Employment Rights Act. So that is specifically that they should not be calculated on the basis of a percentage, and that there is no mechanism in the working time regulations to reduce holiday entitlement on a pro-rata basis to account for part-time working. So essentially, if you were doing so, you are no longer able to pro-rata if somebody, for example, works 26 weeks a year rather than the full 52 weeks. Okay, Joe's now going to look at some of the holiday pay calculations.
Thanks, Kathy. Good morning, everyone. So Kathy's taking you through the Supreme Court decision in terms of the amount of statutory holiday that a part-year worker is entitled to. And I'm going to take you then through the calculations to work out how much you pay someone who works on a part-year basis when they do take holiday. So the starting point for this is looking at the working time regs, which provides that a worker is entitled to be paid at a rate of a week's pay in respect of each week of annual leave they take. So the question then really is how you calculate a week's pay, particularly if a member of staff has hours or pay that varies, or that their pay depends on the amount of work that they do. So the Employment Rights Act sets out 4 different methods of calculating based on different categories of staff and the type of work they do and how they're paid. And so these categories are workers with normal working hours who have pay that doesn't vary, and that will be most of your term time only workers. So many charities have flexible working arrangements with their staff so that staff can look after their children during school holidays and have agreed term time only working. So that category would fit here. And then the second category is workers with normal working hours with pay that varies according to how much work is done. So this is sort of traditionally piecework, so manufacturing, where the output of the employee affects the rate of their pay, and probably not that applicable in a charities context. And then the third calculation method is for workers who have normal working hours with pay that varies according to when they work. So this will affect anyone who has enhanced pay for certain shifts. So if you're in the care sector, for example, and you have staff who work night hours or weekends, unsociable hours, that they get paid an enhancement for those hours above their normal hourly rate. then this category is applicable to you, and you would use this method of calculation to work out holiday pay for those staff. And then the final category is staff with no normal working hours whose pay varies depending on how many hours they work from week to week. And so this would normally be your casual workers, so any worker who's not got guaranteed working hours and that their hours fluctuate depending on demand. So the Supreme Court decision has confirmed that it's these 4 categories and methods of calculation that you must use to calculate a week's pay, and that you can't use the 12.07 percentage method that Kathy just explained. And that when staff take holiday, if they're part-year workers or any worker, they're entitled to 5.6 weeks paid holiday per year. And if we look a little bit more detail at the first category, so normal working hours with pay that doesn't vary, this method's going to apply to most of your staff who have a fixed number of hours every week. And so the same amount of pay that they receive when they're working is the amount of pay that they should receive when they're on holiday. You can have this category of workers who are paid at a point where they take their holiday. So they might be paid their normal salary through working weeks of the year, and then have elected holiday time. They're paid their normal salary. Or you might pay these staff on an annualised basis so that they have a consistent salary throughout the year, and that their pay doesn't drop off during holiday times. And if you're using the annualised method, what you would do is add up their pay for their working weeks of the year. So it might be 32, 39 weeks a year. If they're working a term time only model, then you would add on 5.6 weeks at the same rate of pay that they get paid. And then you would divide that by 12 to get an average monthly pay. And when they take holiday during the school holiday time, they're getting their same salary at the time they're taking their holiday, so they're receiving holiday with pay. And this method is, from an administrative point of view, easier to put in place. It suits the term time only model. And if we look at how we calculate holiday for salaried workers, if they're doing some occasional overtime. So overtime, and whether it's included as part of someone's normal remuneration, has been the subject to quite a lot of case law in recent years. And the position would be that if you're doing guaranteed or compulsory overtime, then that becomes part of your normal pay. And so when you're taking holiday, you should receive the same pay as when you were doing that work and the overtime that you normally receive. And so it would be part of the holiday pay calculation for a normal week. If you have staff who do voluntary overtime on an ad hoc basis, and a few hours here and there extra to fulfill an unexpected demand for extra work, or to cover someone else's holiday absence, then those ad hoc hours of overtime aren't going to be part of their normal working week, their normal hours, and so wouldn't be included in your holiday pay calculation. If we move on to the next slide, please. So if we now look at staff who have normal working hours with pay that varies according to the amount of work that's done, so piecework, here you need to be able to work out the average hourly rate of pay. So that's looking back over a reference period of 52 weeks, taking out any weeks where they haven't earned any pay, working out what their average rate is, and then timesing that by the number of hours they work in their normal working week. That will give you their week's pay, and when they take their holiday, that's the rate at which they will be paid. And this is for those who have normal working hours but pay that varies according to when their work is done, so shift work. And this is done in a very similar way to the previous method. So you look at a reference period to calculate their average pay, so that when they take holiday, you're taking into consideration not a period where they might have done a lot of enhanced night work, for example, and had a really high period of pay for that week, or conversely, a period leading up to their holiday when they haven't done any enhanced work and have received a lot less than they might normally have. So if you look at a reference period over 52 weeks and you average out what their hourly rate of pay is, taking into account any enhancements over that longer period, you get a fairer idea of what their average pay or normal pay would be. And then you would multiply that hourly rate by the number of their normal hours of work in that week to create the figure for their average normal week's pay, and that will be the rate at which they get paid when they take their holiday. And if we look at staff now who don't have any normal working hours, so their hours fluctuate depending on demand. This could be 0 hours workers, a bank of casual staff that you use from time to time as you need them. This is the type of work that Mrs. Brazel had, that her demand for her work varied depending on the demand for lessons for the instruments that she taught. So from week to week, pay could be quite different for this category of workers. So what you would use here, and what's provided for under the Employment Rights Act, is a 52-week reference period again, where you look back over 52 weeks from the point where they're taking the first day of their holiday. So you look back retrospectively at what their average earnings have been during that period of time. And you only take into consideration weeks where they have earned something or where they've been working. And for any weeks where they haven't received any pay, you would exclude those from the calculation, and you then substitute them for a further week, going back to a maximum of 104 weeks, so 2 years, and you put in a week into the calculation for where they have earned. You then divide that by 52, and that will give you your normal week's pay. And so you would carry out that calculation at each point that they're taking their holiday through the course of the holiday year. For staff who haven't been with you for a full 52 weeks, you would average it out over the amount of weeks that they have been working for you. Or if it's even shorter period, then you would look at what is there in the circumstances. So you would look at what others doing a similar work pattern would be receiving in their holiday pay, for example. So some of the questions that we've received since the judgment came in, we're just going to cover now. So can we prorate holiday entitlement for part-time staff? And Kathy's already covered this. The answer is simple, is no. If someone's working on a part-time basis, then they're entitled to 5.6 weeks holiday per calendar year. However, their pay will be reflective of the fact that they work less than full-time hours. So when they receive their holiday pay, it's not going to be at the same rate as someone who works a full week. So if someone's working 2 days a week, a week's holiday for them is 2 days and the same pay that they will receive for that period. So are permanently retained staff who work for multiple employers entitled to 5.6 weeks holiday pay per employer? The answer to this is that yes, that you would look at it on a contract by contract basis. So for each employer they work for, under that contract, they're entitled to 5.6 weeks holiday. And so if their normal working week is made up of working some hours for one employer, some hours for another employer, if they're taking a week's holiday and they're taking it from all of their employers at the same time, they're going to receive the same pay that they would normally do from their employer when they're taking a week's holiday. So yes, you would be, as a worker working for multiple employers, entitled to 5.6 weeks from each employer. So another question that we've been asked is, do employers need to prorate contractual holiday, or can employers still prorate contractual holiday? And the answer to that is yes, you can prorate contractual holiday. The judgment in Brazel applied to statutory holiday only. So if your contracts provide for prorating of contractual holiday, you can do that. You'd need to just check your contracts to make sure that that's the case. And you need to make sure that in all circumstances, the worker receives no less than 5.6 weeks holiday a year after that prorating has been applied. If we move on to the next slide, please. So if we look a little bit more at the impact of the judgment, so we've been asked lots of questions from employers to think about, should they be changing their contractual arrangements? Should they be reviewing and looking at different ways of engaging staff as a consequence of this judgment to ensure that there is fairness in the amount of holiday that staff are entitled to, or to manage the potential liability of extra costs now around holiday. So if we look at the different types of arrangements, if you've got casual staff who work variable hours contracts, these contracts can be very useful in terms of meeting demand when you have it and when you need staff. And if you engage staff on a year-round basis using these contracts, you are going to be required to pay 5.6 weeks holiday going forward. So the benefit of these kind of contracts is that you don't have to redo the onboarding process of new staff. So you're not entering into a new arrangement with them each time. You've got them on your book, so they're there ready and available to work if you need them. The downside of this is if you don't need them that often, they are receiving a disproportionately larger amount of holiday than perhaps other staff who are working all the way through the year. So you might want to think about using these staff more regularly, making sure that if you're offering these kind of arrangements, it is because you need staff working throughout the year rather than sort of seasonal workers where this might not be the most applicable or sensible arrangement going forward. If we move on to the next slide, we can look at using fixed term contracts. So in circumstances where you might need a worker just for a short period, a particular project, or because there's a seasonal demand, it might make sense to use a fixed term contract where you are able to prorate the amount of holiday to the amount of time that they've worked or will be working for you, and to pay that holiday at the end of the fixed term contract, rather than keeping someone on the books throughout the course of the year and then becoming entitled to 5.6 weeks holiday. So using fixed term contracts might be a sensible way forward and something to think about, depending on the kind of work that you're asking that individual to do. One thing to bear in mind, though, is that if you're using frequent fixed term contracts on a back-to-back basis, and you run risks around there being continuity of employment implied, and only temporary cessation of work between each contract, so that you're getting in a position where that person really is seen as being engaged with you throughout the course of the year, and the fixed term relationship there wouldn't really work or be as applicable. If we move on to the next slide, please. And then another type of working arrangement to look at is the use of umbrella contracts. So if you have an organisation that relies on staff who are on a bank basis and work with you, you might want to use an umbrella contract which sets out the terms that would apply when that member of staff is offered work and is on assignment, and when they are on assignment, they would be seen as a worker or an employee, and they would be accruing holiday rights, for example. But when they're not on assignment, there's not an ongoing relationship, and they're not accruing holiday in the same way. So these can be quite useful contracts in that sense, that you could pay the individual in lieu of holiday that they've accrued during each assignment, and so you pay on a pro-rata basis based on the work that they do at that time. The risk with these kind of contracts is that if they're not carefully drafted, and that the umbrella arrangement starts to appear more like a normal casual worker arrangement, and that there are starting to be obligations there and expectations, then it's likely that they'll be seen to be engaged on a worker contract throughout the year, and the 5.6 week holiday provisions would apply. So looking at each contract is really a balance between financial savings that you might make from having the use of fixed term contracts or putting other arrangements in place, sort of balanced against the inconvenience that you might have from repeating onboarding processes, doing various vetting checks for individuals if you're working in a charity that's in regulated activity. And so it's really looking at a case-by-case basis for the type of workers that you have and the demand that you have for what is the right contractual arrangement to have in place. But if you do use a lot of casual workers, variable hours workers, but on an infrequent basis, you could find that the cost of additional holiday is significant, particularly if you're working under tight budgets. And so looking at changing to some of the other models that I've just discussed might be an appropriate thing for you to do. So if we move on to the next slide, please. And to set another poll. So have you received any queries from your staff yet about the Brazel judgment? So answer yes or no. If you vote now. Just wait for those results to come in. No, well, that's quite a strong response. So at the moment, no, 97% no. It may be because people are away on holiday at the moment, but it may be that your charity isn't in a position where you're employing a lot of casual workers or using a lot of term time only staff. It's certainly been a case that has had a lot of interest within the school sector, and whether that has filtered through to charities, maybe not, and that might be why there is such a high proportion where no one's asking. But it's still good to get ahead of the curve and think about your arrangements going forward, even if staff aren't claiming in relation to potential back pay issues, making sure that what you're doing going forward is compliant, is a sensible way forward. So I hand back over now to Kathy.
Thank you, Jo. So now we're going to look at sort of, it is interesting you've had so few queries, but even so, you need to decide as an organisation, and particularly in the third sector where you will want to be compliant, what you're going to do about this change in approach that is now not going to be overturned unless the government intervenes by redrafting the working time regulations. So the first thing I think you should be doing in any event, whether or not you've had notification of potential claims from your staff, is identify whether you have in fact been underpaying staff. And the first thing to look at is how you have calculated holiday pay. Now, we know that if you use 12.07% for anything other than 52-week-a-year staff, there will definitely be an underpayment. So if you've used 12.07% for part-year workers, then you will have underpaid them. If you've paid a higher amount, but using a percentage calculation, so say, for example, if you've paid based on 14%, if your contractual entitlement is 6.6 weeks holiday, a percentage is probably still not an appropriate way of calculating holiday pay moving forward, but you might find when you look at individual contracts that there is either a much reduced underpayment or indeed no underpayment at all. And that will obviously depend on how few weeks the individual works, because as we saw in the earlier examples we gave, as the number of weeks worked gets smaller, the percentage you need to pay in terms of holiday pay increases. So check your method of calculation. And then the second thing you need to do is to look at what does your contract say. Now, it might well be the case that even for part-time workers, so say a term time only worker, your contract does say that actually somebody is entitled to 5.6 weeks holiday. And on the face of it, that is absolutely fine. You've provided for example, working 32 weeks a year plus 5.6 weeks holiday. They're paid an annual salary divided by 12 to cover those hours. However, what you need to do is still to look behind that contractual statement to see what your payroll calculation has actually been. And the reason for that is you just need to sense check that there's no inequity in pay rates between term time only and full-time staff, and also that you're in compliance with national minimum wage, national living wage requirements. So if we take the example of somebody who works 26 weeks, and although the contract says that they're entitled to 5.6 weeks, what we're finding is quite often the payroll calculation has prorated that 5.6 weeks. We've had a number of queries on this already from organisations. So actually that individual is only being paid for 28.8 weeks, whereas if they'd been paid for the full 5.6 weeks, they should have been paid for 31.6 weeks. So that just gives them a reduced hourly rate compared with other people who work full-time, which could result in other claims, but also might give you national minimum wage issues. Next slide, please. So you've identified whether there's been an underpayment, and it may be, given that a lot of you think you're not impacted, you have either generous holiday paying calculations and staff who work most of a year, so this may not be an issue, but you should decide, identify the underpayment, potential underpayments within the organisation, and then also review the risk of a challenge. And we've said that you should do that by looking at the calculations which underpin existing salary calculations. And staff may well, when they do become aware of this, or if they pick up on it, may challenge you to evidence how their salary or hourly rate was actually calculated, and they would be entitled to do so. And if you tough it out on the basis that your contract says, well, it says 5.6 weeks, and actually there is inequity in pay, then that could lead to grievances and ultimately to litigation. The other reason a review may well be necessary is this will be identified by auditors as a potential liability on organisations. So if they become aware that you have casual staff or part-time year workers, they may well want to review your calculations and to make provision for any latent liability, even if you decide not actually to address it with your staff. So our advice is very much to do a proper review of each of your contract types, work out any actual underpayments and identify then the risk in respect of each contract type and the potential liability for any back pay before you decide on what you're going to do. Next slide, please. So when you've identified whether you are in fact underpaying staff or have been underpaying staff, you also need to consider about whether to correct or how you correct holiday pay going forward. We of course wouldn't recommend that you continue to pay incorrectly to staff now that the Supreme Court decision has been handed down. I mean, we're going to talk in a little bit about the 2-year back pay provisions on claims, but the advice has very much been wait and see what the Supreme Court does, because your liability hasn't essentially been increasing whilst imperceptibly and gently reviewing contract types. So looking forward now, review your contracts and amend them if that's required. So when we did the review, we will have identified any contract wording that needs to change or be clarified. So if your contract refers to 5.6 weeks holiday, it is going to be okay. But if it expressly says that holiday will be calculated on 12.07%, then it needs to be amended. If you've identified that although the contract is okay, your practices and your calculation needs to be changed, then the judgment, I think your contract will need to be changed. Pay calculation will need to be changed in order to put the correct calculation in place with the increased percentage in place for people who work part year. I think it's quite likely that the judgment may have some unintended consequences as well, because if there is an additional cost on an organisation to cover additional holiday pay, then charities and other organisations are going to look at how to manage that. So as Jo said, one approach would be to use fixed term contracts with all the caveats that she said about them not being subject to temporary cessation of work between. But the advantage of that is if you have a fixed term contract, you can prorate holiday pay in the first year. So to give the example, if you work half a year for 6 months, under a fixed term contract, then the entitlement holiday is 2.8 weeks holiday pay. But if you're on a permanent contract and you work 6 months in consecutive years, then you will need to pay the full 5.6 weeks holiday pay on an ongoing basis, which sort of highlights the inequity in the approach that this causes. I think there is a risk that people will reduce the use of term time only in other part-year contracts going forwards. I mean, within the third sector, term time contracts are quite prevalent. And also perhaps review the use of casual working and bank arrangements and perhaps put those on a less secure footing. And it also might mean that where individuals make flexible working requests for compressed hours into few weeks in order to help with childcare over holidays, if there's a severe financial impact on the charity, these requests may not be allowed. In terms of how you put things right, some organisations, if the pay review falls appropriately, are incorporating additional holiday pay entitlement into that general pay review. Obviously, a lot of pressure on salaries at the moment, given inflation. So this is another factor that perhaps could be rolled into that salary review. However, if you do that, which does seem sensible, if you've got pay negotiations ongoing, then you must be transparent about how holiday pay is being provided for and calculated moving forwards. What you don't want to do is to do a enhanced pay review to take into account and then have further claims because people claim that that was just their pay review and didn't address the holiday pay going forward. I mean, in line with all other sectors, really, charities are suffering from funding pressures. And if employee costs go up significantly because you have a number of term time only or casual workers, then employers might need to claw back those costs in other way. So in the Brazel case, that was likely to have been through an increase in tuition fees or school fees, so that the additional cost for the visiting music teachers could be recovered. In other organisations, it might be that there's more pressure on other benefits for employees due to the increased cost of holiday pay. So really the two approaches are to stop using part-year contracts or to build those costs in elsewhere into your financial model. Next slide, please. So there is a little bit of good news. Essentially, if people have an arrears of back pay that you don't settle or compromise in some way, then a claim would be by way of an unlawful deduction claim in the employment tribunal. And when this started being an issue way back in 2014, the government introduced a new set of regulations, the Deduction from Wages Limitation Regulations 2014, which introduced a 2-year limitation period so that people bringing unlawful deduction claims can only go back for 2 years in relation to underpaid holiday pay. I suppose the good news is, however unfair and frustrating this judgment appears, that previously, before the 2014 regulations, there would have been a minimum of a 6-year back pay liability, and arguably, depending on complicated legal arguments, that the potential liability could have gone back to the introduction of the working time regulations. So the 2 years is still a lot, but it's far better than it could have been. There is another argument in relation to limiting holiday pay claims that was raised in the case of Bear Scotland against Fulton, and you might have seen this referred to in commentary on the case, on the Brazel case. So the general time limit for bringing a claim for unlawful deductions is 3 months. So if you, for example, rectify holiday pay going forward and employees don't bring a claim for back pay, then subject to all of the procedural requirements, then there will come a point when they actually are unable to bring an unlawful deduction claim. And the Bear Scotland case looked at whether deductions from holiday pay were effectively and ongoing throughout the whole period of where holiday pay wasn't calculated correctly, or whether if an individual had been paid correctly for a 3-month period, that effectively broke the chain of that series of unlawful deductions. And although the case was primarily about overtime payments, it concluded that if there had been a 3-month period where an individual had been correctly paid, then they wouldn't be able to bring an unlawful deductions claim for underpaid holiday prior to that 3-month gap. So that sounded quite good news for employers. However, there have been 2 Court of Appeal decisions which have thrown that into doubt, although neither of them are directly enforceable in the UK. So one was the Northern Irish case of Agnew against the Chief Constable of the Police Service of Northern Ireland, where the Irish Court of Appeal expressly said that this was not good law. And then this year in Smith and Pimlico Plumbers, the Court of Appeal for GB expressed a strong provisional view that this 3-month rule would not survive an appeal. So if you try and reduce your 2-year back pay liability because of a previous 3-month break between payments, we think that is ultimately unlikely to succeed, and it might not be an attractive argument to pursue for charities at the moment. Okay, next slide, please, Tamar. So, what's your best commercial approach? You've identified that you've got an underpayment. You need to rectify it going forward. But in relation to back pay, how are you going to work out how to sort that out? And I think to some extent, you know, what you do does depend on the views of your staff, but also on your view of yourself as a charity and employer as to whether you feel that you should be complying with statutory obligations. And a lot of charities I know will feel that they should. So you could carry out individual calculations to obtain a precise figure for each employee. This can be very complicated depending on the nature of the employment, because holiday pay has to be essentially calculated at the point it's paid, and Joe went into that a little bit of detail, and therefore can just be very time consuming, particularly if you have a large number of part-year workers. So if you've got a small number, it might be the best approach. If you've got a large number, you might be looking for a bit of a shortcut. You could come up with a percentage figure that you know exceeds the statutory minimum. So that would work well, for example, if you've got a number of, say, term time only contracts, so that you know a number of people work 32 weeks, you can just say, well, we know that they received holiday pay based on 12.07% or equivalent, and actually what they should have done for everyone who worked 32 weeks, the percentage should have been that. So we'll just pay the difference for that category of employee. And I think that's very practical, and that will work well for some employers. It works less well with casual workers. And then perhaps if there are a number of bank staff or casual workers who've had very erratic working patterns, which will inevitably give them varied calculation on holiday pay depending when it's deemed to have been taken or was taken, offer everyone a fixed sum in satisfaction of any back pay claims. Okay, next slide, please. So still looking at how you're going to pay holiday pay moving forward. This is obviously something you will already have considered in relation to those staff, but I think with the increasing focus on holiday pay, particularly for those categories of staff, you might just need to check that you're happy with when you're paying holiday pay. So for salaried staff or annualised hours staff who are receiving 5.6 weeks pay, paid holiday and are paid monthly, it's just part of their regular monthly salary. So provided your pay calculations are correct, so you've taken into account the correct holiday pay entitlement, that works well and shouldn't need changing. For staff whose pay varies or who don't have any normal working hours, then you basically need to decide when they take holiday and when that is paid. Some contracts are very vague, so it could be you can take 5.6 weeks holiday in the school holidays, or we take the school holidays and 5.6 weeks of it is paid. I suppose it's easier if there's a bit more specificity about when the holiday is taken, and therefore that triggers when the holiday pay is calculated, particularly for variable hours and paid staff. So people are looking at scheduling in holiday at specific points in the working year on non-working weeks, identifying that as holiday, and then doing payroll calculations at that point. So that could be on a quarterly or a termly basis, as appropriate for the particular individual or contract type. And for casual workers, as Jo said, if you've moved them to short-term employment contracts, there's no continuity between. That calculation would be done at the end of each assignment. So just to reiterate, you will need to carry out a new calculation each time you make a payment. And we've identified that you calculate weekly pay as an average over the last 52 weeks. That was changed, that was increased to provide more consistency. And that is any amount of weeks up to 52, but looking over the last 104 weeks as a reference period. So, it is quite a complicated calculation to do. So any way you can do by scheduling holiday and fixing when it's taken and the pay calculation will assist in administration moving forward, and also transparency, so you can explain it clearly to employees. Next slide, please, Tamal. Then we identified that the contracts may or may not be correct. So what does the Employment Rights Act say about holiday and holiday pay, and what has to go in the contract? Well, Section 1 says the contract must include terms and conditions relating to the entitlement to holidays, including public holidays and holiday pay, and that the particulars given must be sufficient to enable the worker's entitlements, including any entitlements to accrued holiday pay on termination of employment, to be precisely calculated. And I have to say, over the last few years, with all the uncertainty, a lot of contracts have been fudged and really wouldn't have complied with that Section 1 requirement. So what your contracts need to say is, it needs to say that either all staff are entitled to 5.6 weeks paid annual leave, or perhaps, given that there is, even if a remote possibility, that the government may legislate to change the working time regulations, to say that all staff are entitled to the statutory minimum amount of holiday, which is currently 5.6 weeks, and that might just give you some room to change it if the Brazel decision is reversed by changes to statute. What you don't want to do is to give people who work, 26 weeks, a contractual right to 5.6 weeks holiday pay if you can avoid it. It's really important that you're very clear on the position on public holidays and whether they're included or not included in the 5.6 weeks paid annual leave that you are going to give to part-year staff. And obviously we would recommend that that is included. It can be, and there's no reason why you shouldn't include it. The danger is when you start tweaking one clause, you forget to follow that through into other clauses. So be absolutely clear on the treatment of public holidays. For salaried staff, the contract ought to confirm that holiday pay is paid by way of the monthly salary. And for hourly paid or irregular hours staff, you need to confirm how holiday and when holiday can be taken, and how and when it will be paid. Okay, next slide, please. Only really, I suppose we would say, when you've done all of that research and review, should you then communicate substantively with staff, although you may wish to say something about the fact that you're reviewing the impact on your contracts, if it's an issue for you, or if you have a significant number of staff, or perhaps if you have a couple, you might want to just have a quiet word with them and say that we understand that they are impacted by this and you're currently reviewing it. I think the unions are looking at this. The actual amounts per employer are often quite low, which might account for the fact why a number of people and organisations are not really seeing this as a big issue to pursue. It's complicated. and if the overall award is potentially low, then perhaps people just can't be bothered at the moment. But you know, there will be more communication about this, and there will be some union action. There's already been quite a lot of publicity about it. So be very clear in your communication with staff. Are you satisfied that there hasn't been an underpayment? And if so, why? Explain your calculation, or identify that there has been an underpayment, and set out clearly your proposal for dealing with that. And then if contractual changes are required, be very clear about what the contracts changes are, and whether it's just to clarify the position, because actually there is no underpayment and the calculation is correct, or it's to rectify the situation moving forward, and be very clear on the apportionment of salary and holiday and how those two interrelate, so that you have consistent payment for the same role across the organisation, whether it's done on a 52-week year or a part year basis. Next slide, please. So in summary, you're going to review your contract wording and check that that's complies with the decision, and then check the actual calculation so that you are sure that the calculation you're applying also complies with the decision. You're going to change your contracts and the method of calculation if you need to do so, and that will effectively rectify holiday payment going forward, so it's compliant, and you're going to decide on your approach to back pay, whether that's going to be a change the holiday pay going forward and hope you don't get a claim, or sort out any back pay claims on the basis of one of the options we've discussed by precise calculation, percentage calculation, or by making a lump sum offer. And then you will need to communicate with staff, and including and particularly about any contract updates that are required. Okay, I think that concludes the presentation now. So I know we've got some questions in the Q&A box, and we've got a few minutes left where we can look at those. Jess, can I leave you to field those, because I haven't been looking at them because I've been speaking?
Yeah, absolutely. So we have been trying to answer as many as we can get through as you've been talking. There's a few themes that have come up, so perhaps if we just talk generally. Firstly, I think it'd be useful to go back over pro-rating contractual holiday that is given in excess of statutory entitlements. There's been a few questions on that.
Yeah, and we've actually had quite a few questions from organisations about that as well. So if you have a much more generous contractual entitlement, so for example 6.6 weeks, then you might have applied a percentage calculation, 14%, to term time only or other staff. The method of calculation isn't correct, but if you apply the correct method of calculation and it doesn't drop below 5.6 weeks for a member of staff, then there's no liability to pay any additional staff. So you don't have to prorate the whole, you don't have to take the 5.6 weeks out and then prorate the extra week. You can prorate the whole lot and then check that the 5.6 weeks is complied with. Is that okay?
Yeah, absolutely. Thanks, Kathy. And then the other thing that is generating quite a lot of questions, and I think it is especially for casual staff, it's this question of, well, if they're not working, how do we know when they are taking holiday? When do we know how to pay it? And I think it might be useful to just talk about the extent to which that kind of thing can be controlled under the contracts of employment. Oh, Kathy, you're on mute.
Just going to say, I think Joe probably is best placed to pick that one up.
So I suppose with casual staff, if they're working throughout the year, and so there's not a time where you would ordinarily say that they're taking holiday, it's to ensure that you're policies with those staff and that your dialogue with those staff is encouraging them to take holiday periodically, and making sure that you have records of the time that is allotted to holiday, and that you've done the calculation. So you're looking back over the reference period at the time that they are taking that holiday and ensuring that it is paid. The previous method of using the percentage was really easy because you could apply it and you would ensure that they had pay at that time. But if you're applying the law correctly, you need to be allocating time for holiday and ensuring you're doing the calculation at that point. Hopefully that answers the question. I don't know, Kathy, if you've got anything else, or Jess, you want to add anything to it?
I was going to say, we've had a couple of clients who've done it, and they're effectively rostering in holiday at a fixed time in the year, and then they can do all the holiday pay calculations at the same time, rather than, and it very much depends on the nature of the casual work, because if it's overflow work, it's really hard to do that. But obviously, if it's casual but more predictable, so it's seasonal, for example, I mean, in the education sector, invigilators, for example, then it's easier to actually look at the periods when you know you're not going to require it, fix a time for them to take it, and then just do the calculation at that point. Jess, have you got any other?
Yeah, that's what I was going to say, and obviously making sure that any casual irregular hours workers are actually away from work for at least 5.6 weeks of the year. And also the fact that you can designate in the contracts the blocks of time where holiday can be taken, because you can get quite quickly into quite murky waters if you've got somebody who works irregular hours. And then the question arises as, what is a week's holiday for somebody whose weekly hours fluctuate that much? So it is worth looking, I think, at how you're expressing all of that in your contracts. And just tightly controlling that, and it helps you from an administrative perspective as well.
Yeah, I absolutely agree. The whole reference to weeks pay is really unhelpful in the context of so many modern employment practices. It's just a very antiquated piece of legislation that is long overdue a complete rewrite, but no plans that we've seen to do that, unfortunately.
That brings us, I'm just looking at the time, we're just up to a minute over. There are a few questions remaining. Some of them are pretty specific, and I wonder if we take them offline. I think we've captured the main themes.
Yes, are we able to, I'm sorry, I don't know about, are we able to respond to the specific questions direct to the individuals concerned? Yes. Yeah. So we commit to do that afterwards. So if we haven't got to your question and it's still unclear from what we've said, then we'll drop you a line to confirm the answer. And of course, if you have any other questions, then please do get in touch with one of us.